So my introduction of Gov. Gov Hutchinson is the Assistant General Counsel for the California Association of Realtors. Gov has been with C.A.R since 1985. He manages C.A.R's member legal services program in Los Angeles. Gov advises realtors through the hotline on all aspects of real estate law, and he trains and supervises other hotline attorneys. Gov received his bachelor's degree in history from Princeton University and his Juris Doctorate from the University of Pennsylvania. With that being said, here's the Gov.
All right. So the camera's over there, right? I got to look into the camera. Okay. First of all, no karaoke for me. I don't play around. And actually on Halloween, I'm doing a presentation like this up in Modesto. And they said, "Oh, we're all dressing up for Halloween. Can you dress up?" I said, "No." "Can you at least wear a mask?" "No." "I'll dress like a lawyer." How's that? So anyway, good to see you guys. It's like deja vu, right? Wasn't that long that I was here before? This is sort of that was sort of the special visit. This is the regularly scheduled visit that I do every year at this time. So sort of what I do, obviously, when I come here every year, as you remember, is I talk about all the new laws that just got signed, and I'm going to do that. But I know we still want to talk about this buyer broker stuff because there's sort of ongoing developments with that. And I'm sure that's everywhere I go, that seems to be the main topic of conversation anyway. So I'd be glad to talk about that. I'll start off with some of the new laws that the governor just signed. He signed a bunch of them. Several of them have to deal with rentals, as always. Talk about like 5 new laws and take a wild guess. Do you think these new laws are going to be pro-landlord or pro-tenant? You're right. I cannot remember the last pro-landlord law that was passed in California. So every year it gets a little more challenging to be a landlord. By the way, you've probably already talked about this, and C.A.R is making a big push about Prop 33, right? That would be a really bad rule for landlords. Remember the basic rule in California we have, rent control is legal. Some people still ask me, how can rent control be legal? That's taking someone's property, and unfortunately that's already been litigated all the way to the Supreme Court. So rent control is legal. But California passed a law called Costa-Hawkins many years ago, sponsored by C.A.R., to at least put limits on that. It said basically, okay, cities, okay, counties, okay, California, you can impose rent control, but there are limits. You cannot impose rent control on single-family homes. You cannot impose rent control on new construction, and you can't impose rent control on new tenants. Prop 33 would take that away. It would overrule Costa-Hawkins. It would enable local governments, including the state of California, to put rent control on those 3 things that I just mentioned. So that's why it's a big deal. That's why C.A.R is really making a big push against it. So hopefully we'll be successful. But that's when you hear about, tell your friends, vote against Prop 33. C.A.R's, we'll have a lot of media out there, but that's sort of a big deal. All right. Speaking of that, remember that we do have California. I know you say, I don't have rent control in Bakersfield. Well, everyone has rent control. California has rent control, right? Tenant Protection Act, which applies to rentals of 2 or more, on properties that have 2 or more units, 15 years old or older, right? So if you guys have if you have a rental property that fits into that category, it's a triplex, it's 20 years old, you're under California rent control, right? And that, what always happens every year, remember, August 1st is, there's a limit on how much you can increase your rent on one of those properties. And the limit is always it's somewhere south of 10%. It changes every August 1st. It just changed August 1st. Does anyone know the number for Kern County? You're so close. You're also close. 8.8. So I'm not 8.7, not 8.9, 8.8. So be careful. You have a limit on how much you can increase rent on these properties. By the way, here's a question I get sometimes. Duplexes are exempt if you live in one side. So if I have a duplex, I live in one, I rent out the other one, I can do whatever I want. Another So let me say, what if I have a house and a guest house, a house and an ADU? So there are two structures on my single family lot. If I rent that out, is that a single family exempt from everything? Or is that a duplex where I'm under this restriction? And the answer is it depends on, do you rent the whole property? If you rent the whole property to one tenant, they get the house and the ADU. It's a single family, you're exempt. But if you just rent out one of the two, you're not exempt. Yeah, but what if I live in one? Well, the exemption for living in one only applies if they're connected. So if you're, let's say you converted your garage into an ADU. So that's a duplex for purpose of this law if you rent out the garage or the main house. But if you live in the other half, you're not exempt. I mean, you are exempt. Don't you have a headache already? I don't want you to try to remember any of this. Okay, don't remember any of this. Just remember, have a vague idea in your head. Before I increase someone's rent, I better check with someone like Gov, who's going to remind me how old is the property, how many units. Because another thing would happen is you have a house and an ADU, but the ADU is less than 15 years old. And then you could do whatever you want too, right? So there are all sorts of exemptions, all sorts of rules. And remember, I think I told you last year that it's harder to evict someone for a family move-in. Remember, you used to be able to say, I'm evicting you. Why? Because family member is moving in. And your wife's third cousin twice removed could move in. Now it's got to be parent, grandparent, child, grandchild, or my favorite, your spouse. Honey, you got to move into the rental. It's just business. It's just business. Nothing personal here. So anyway, so that's the latest on the Tenant Protection Act. All right. So 8.8, and it's harder to do the family move-in thing. But here are the 5 new laws you should know about regarding rentals. And then we'll move out at rentals. One of them is every landlord in California is going to turn into a photographer. Let's say the tenant is leaving and they've damaged the property and you want to deduct from their security the cost of cleaning or repairing. Okay. Effective April 1st, when a tenant moves out, you have to take pictures of the property if you want to deduct anything from the security. And then after you do the cleaning or the repairs, you have to take more pictures. So when you give them the notice that says we're deducting this, you have to give them the before and after pictures as well, which hopefully will support the deduction that you're making from the security deposit. Okay, so that's April 21st, pictures. Starting July 1st, for new tenants, you'll have to take the pictures before they even move in. So there'll be 3 sets of pictures, right? The picture when they moved in, the picture when they moved out, and the picture after you did the repairs or the cleaning that you wanted to do to deduct from their security. What if you're not going to deduct anything from their security? You don't have to take the pictures because their pictures are related to deducting from their security. This new law also says that, did you know that some landlords will put in their lease something like, tenant agrees right up front that when you leave, we're going to pay a professional carpet cleaner to come in and clean the property, and you agree already that that's going to be a cost deducted from your security. Well, the new law specifically says you can't do that. You can't automatically have a provision that you're definitely going to hire a professional carpet cleaner, a professional cleaner of any kind. I mean, if that's reasonably necessary to restore the property to its move-in condition, absent ordinary wear and tear, if that's reasonably necessary, then you can hire a professional cleaner, professional carpet cleaner, but you can't make that an automatic term in the lease. I don't know if any of you guys do that or if you guys know that, but so that's the latest thing on that law. Okay. Second new law. And by the way, we have a handout on our website that summarizes all this. Just search for summary of 2025 new laws. It has all this stuff. Another one is not a big deal, but did you know and I never thought this was probably legal anyway, some landlords, when they give you a notice to quit or notice to vacate or something like that, they charge a fee for that. And they even put that in the lease. That's now impermissible. It's impermissible as a landlord to charge a tenant a fee to give them an eviction notice. To me, that's always like, kicking them when they're down, right? You got to leave and you got to pay me for me telling you to leave, so don't do that. Don't do that. Not that you were doing that anyway, but don't do that. Okay. And that's also effective January 1st. And here's a kind of a weird part of that law. It says, by the way, can you charge different tenants different security? Yes. If you have a basis for that. Of course, right now you can only charge 1 month's security, right? Unless you only have 4 units or less, which case you can charge 2. But you could actually have 2 tenants, different security requirement based on their credit history or their rental history. You don't have to treat everyone the same if you have a reasonable basis for doing that. But this law, it's kind of interesting to me. It just says, if the tenant happens to be a service member in the military and you want to charge them a different deposit than your other tenants based on their credit history or whatever, you actually have to tell this tenant that you are charging them a higher security than normal, and the reason why, and if they pay their rent on time for a year, you have to give them back the extra amount of security that you took. I know your reaction to this is going to be, I'm just going to charge everyone the same security. I'm not going to worry about this. But that's a kind of interesting, but it only applies to certain tenants. Special, if you're in the military and you're charged a higher, obviously you can't be charged a higher security because you're in the military. It would have to be for some other reason. But if that's the reason, you have to tell the tenant and refund the money if they pay their rent on time for a year. So there you go. Third rental new law says, effective January 1st, that tenants have the right to say to you, you know how I'm paying my rent on time? And you say, yeah, you're paying your rent on time. Well, I want you to tell TransUnion or one of the other 2 credit. I want you to tell them that I'm paying my rent on time. I want you to report my positive rental payment information. And you know what? If they ask you, you have to do it. You can charge them $10 a month. They might say, well, in that case, it's not worth it. But you know what I mean? You actually have to, and we're going to, obviously, all these changes that I'm making, we're going to incorporate into our rental documents. But that's a new requirement that residential landlords have to offer their tenants to say, if you want me to, I will report the fact that you are paying your rent on time, to bolster their credit score, whatever. So good news is this doesn't apply to you unless you have a rental property with at least 15 units. And you say, oh, that's good. On the other hand, if you have more than 1 rental property, it applies to you no matter how many units you have. So if you only have 1 rental property and it doesn't have 15 units, you don't have to do this. But anyone who has rental property with at least 15 units or more than 1 rental property, you got to do it. Okay, she's walking over there. We have a question coming up on this one. And I should point that out. I'm sorry. If you have more than 1 and the landlord is a corporation, LLC, or real estate investment trust. So if you're just rent yourself, you or your trust are the landlord, you don't have to worry about this unless you have at least 15 units.
So does that mean you have to you're saying that you have to offer it to everybody or, okay.
Yeah, in other words, we'll put it, we'll obviously have to put it into our lease form. So if you use the C.A.R. forms, all this stuff will be in there. So this is not going to apply to everybody. So that's good news. All right, 2 more to go. And I saved the worst for last. Here's the next to last one. Did you know, as a landlord, if a tenant says to you, I'm a victim of domestic violence. There's a bad guy, and I say guy because it's probably a guy, who's, I'm the victim, he's the bad guy, and he has a key to my place, so you need to change the locks on my rental. If the tenant says that to the landlord has to change the locks within 24 hours. So that's current law. The new law sort of clarifies that. First of all, the first question is, do I have to give any documentation to the landlord? Do I have to give him like a police report or anything like that to justify this? And the answer is no. If you in writing, tell your landlord, because of the domestic violence, you need to change the locks, then you need to change the locks. What if the bad guy, the alleged bad guy, lives in that property? Well, then you only have to change the locks until you get a restraining order or something like that. But we're talking about when the bad guy doesn't live in the property, but he has a key to the property. In that case, you just have to take the tenant's word for it and change the locks in 24 hours. This law also clarifies that who has to pay for that? The landlord. Third thing it says is, what if the landlord doesn't do it in 24 hours? Tenant, you can do it yourself and bill the landlord. And the landlord has to reimburse you within 21 days. Finally, this law says that this law applies to not just necessarily the tenant who's on the lease, but also someone else living in that unit who's the victim. So you can imagine there's one tenant on the lease. Someone else lives there, isn't actually on the lease. They're not actually a tenant, but they live there, and they are the victim. So they would have the right to assert this to the landlord and say, hey, you need to change the locks in 24 hours. Okay? All right? All right. So these are kind of, always makes your life slightly more difficult as a landlord, but you can probably live with them. Also, this law says in the future, separate than this, but related to this, if I'm a landlord and I'm evaluating an applicant, I cannot use against them the fact that in the past, they were a victim of domestic violence. They'd asked their previous landlord to change the locks because of domestic violence. They'd filed a police report. Law enforcement had been out of the property. Any of these things that sometimes happen, you can't use that against a applicant on a previous, on a new tenancy. Which leads to the fifth and final new law regarding rentals. And this, like I said, I saved the worst for last. This one's kind of a big deal. It deals with this whole concept of screening applicants. So I'm a landlord. I have a vacancy. Somebody applies. I want to, do a background check or, credit check and all this stuff. That costs money. And you're allowed to charge the applicant a fee for that service, for that. Do you know how much you can charge them? It started off as $35, but it goes up every year because of inflation, but they never round it off. I bet no one in this room knows the new number, unless you've heard me in the last couple of weeks. $62.02. Don't charge them that third cent, but you can charge them of $62.02. Okay, so that's an update. But here's what this new law says. First of all, it says you can't collect the screening fee unless you have a vacancy. Because sometimes what will happen is a tenant approaches a landlord and says, hey, do you have any vacancies I want to live here? He says, not now, but I can put you on a waiting list. Okay, great. And why don't you just pay me $62 right now, and as soon as we have a vacancy, I'll run the credit, or I'll run the credit now, even before we have a vacancy. Well, the new law says you just can't collect money from a tenant and a potential tenant as a screening fee unless you actually have something available. All right, so that's not a big deal. Here comes the big deal part. The big deal part is it's going to be harder to get that screening fee at all. So let's say today, this law changes in January. Let's say today I have a vacancy. I have 10 applicants. All 10 of them, I collect $62.02 if I want, or don't have to collect that much, but whatever it is. So I collect the 62, and you can't charge that much unless you're actually it actually costs you that much, but whatever it is. So you collect the 10, you run the screening fee for all 10. One of them wins, the other 9 lose, but you don't have to give anybody their money back. The new law says if you want to keep the screening fee for the unsuccessful applicant, you have to do one of two things. One of them is you just can't do it. One of them is to say, well, you have to have a policy that if you don't get it, you get your money back. I'm going to keep it from the one who actually got it. Any unsuccessful applicant gets a refund of the $62. That's one possibility. But then you say, I don't like that possibility. What's the other one? What's the one where I can keep the $62? And the answer is, if that's your choice, you have to actually create a written screening policy that you're going to give to every single applicant. And on this policy, you're going to say, this is the criteria that we're looking for. We're looking for a credit score of this, income of this, no evictions in the past, no felonies, blah, blah, whatever it is. You're going to have criteria, and you'll put them in writing, and you'll give them to the applicant, and this policy has to say on it, and we're going to consider every applicant in order that we receive them, and the first person that meets the criteria we're going to take. In other words, no discretion on the landlord. You can't like interview someone. It says, if they meet your objective criteria and they're the first one who meets your objective criteria, you have to take them. So if that's your policy and you put that in writing, then you can keep the screening fees from the unsuccessful ones. You see what I'm saying? Otherwise, you just got to give it back to every single unsuccessful applicant. So that's sort of neither choice is probably something you really like too much. I will say, you know that second part about having screening criteria and telling the tenant what that screening criteria is and then taking the first applicant? We have always recommended that you do that to avoid discrimination claims. Because let's say today, you know what you're looking for, a credit score, blah, 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 blah. So you get a bunch of applicants and you get like 3 different people meet your criteria. Great, I'm going to interview these 3 people. And the ones I sort of like best, I'll take them. You know what the problem with that, of course, is? The 2 that you don't take are going to say, well, I was good enough to be interviewed. I wonder why I wasn't good enough to, I know why. It's because of my race, religion, number of children, blah, 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 blah. So to avoid that, at C.A.R. attorneys, we've always said, it's better to just take the first one so no one can accuse you of discrimination. But that was just our recommendation. We had no idea that this was going to become a law. It's not like we influenced this law, but the point is, that's your choice unless you want to just give it back, give the money back to everyone. Yes.
So if you don't collect the $62 and you tell them, hey, just go on apartments.com or Zillow and fill out that application, they actually collect it. So you're not obligated to
We don't
reimburse
think
them,
so.
correct?
Or rent spree or something like
Right,
that.
right.
I mean, the question is, a lot of you probably do this where the tenant, they don't pay the landlord, they pay this third party. Is this going to restrict them? And we're not sure yet. We're trying to nail this down and get an official legal opinion, because the argument could be, well, this third party is really acting as an agent of the landlord indirectly. And this law refers to that. It says, well, this applies laws to all agents of the landlord. Would it even go that far? You asked the correct question. We don't know for sure yet. I mean, I hope the answer is no. You don't have to worry
They
about
can
it.
also, it says that you're given 30 days and they can go to different landlords. So it's not like you're only for that.
I don't think it's going to apply, but we'll have an answer by January 1st. That's a really good question. All right. Enough on rentals. Enough to depress you landlords out there. If you're not a landlord, you don't care. Prop 33, that will be depressing, but we're going to fight that one. Other random new laws that you might be interested in is there's a handyman and contractor, and if you're paying someone more than $500, you're supposed to only hire a licensed contractor. How many of you have ever violated? No, don't tell me. I do not want to know. The point is, commonly violated law. Well, the $500 is moving up to $1,000. So effective on January 1st, an unlicensed worker, a handyman, can legally do work on a project that doesn't cost more than $1,000 without a contractor's license, unless the work they're doing requires them to get a permit, in which case you still have got to be a contractor, or unless the handyman is actually hiring someone else to either do the work or help them do the work. For that, you also need to have a contractor's license. But anyway, the basic number is going from 500 to 1,000. All right. Here's a good one. This is actually a positive one. You know that there's this law we call the balcony inspection law. Have you heard about this? Okay, well, I'll tell you about it. There's a law that says every residential property in California that has balconies or decks at least 6 feet off the ground, made or supported by wood or wood-based materials, that people actually stand on. It's not decorative. So it's 6 feet off the ground. It extends from the building, made of wood. You stand on it. Well, that has to be inspected. Those balconies and decks have to be inspected by the end of the year. So there are two situations we're talking about. One of them is like three. I remember I said 3 or more units. That means triplex, fourplex, any apartment building more than 2 units. But it also applies to condominium buildings, even though those aren't apartment buildings, they're single family units. But if the building itself that the condo is part of is attached and it has the balconies or the deck 6 feet off the ground, these all have to be inspected. Okay. So not only do they have to be inspected, if there's any problems, they have to be corrected within 4 months. Okay. So first question is, who can do this work? Well, if it's a condo, it can only be an architect or a structural engineer. They just passed a law to extend that to civil engineers. So architect, structural engineer, civil engineer. If it's an apartment building, triplex, fourplex, or whatever, it could also be a general contractor with a A, B, or C5 license and 5 years of experience. Okay. The good news is the deadline for the apartment buildings has been extended a whole nother year. So it was going to be January 1st, 2025. It's now January 1st, 2026. Not for the condos, though. So HOAs are required to inspect the balconies on the decks of these single-family condos by January 1st, 2025. What if, and it also depends on the CC&Rs, right? I mean, if the CC&Rs say the deck or the balcony is owned by the unit owner, this doesn't apply. So it doesn't apply to single-family home owners, whether it's a condo or not. But if the HOA is the one responsible for the balconies or the decks, they still have to do it by January 1st. At least now it can be a civil engineer rather than the other 2 types, but they still have to do it. And remember, we have a form for this, the balcony inspection disclosure form. It'll be updated, but it is a required form in the C.A.R. purchase contract, okay? Do you with me on that? That's slightly good news. You don't seem that excited, but it's slightly good news. And not everything I say is bad. Okay. A couple more laws. Actually, there's not a lot of new laws this year other than the buyer broker stuff that I think you'll agree. I'm going to talk about form changes as well. Couple more things worth mentioning. Do you know in the foreclosure process how long it takes between, okay, I mean, you could miss a payment and the lender can immediately the next day give you, a notice to pay. Do you know how long it is between that, what the minimum amount of time it is between that day and the actual sale date? It's actually 110 days, right? Because once they give you a notice of default, they can't do a notice of sale for at least 90 days, and you can't have a sale date till at least 20 days after that. So maximum of 110. Did you know if the property is residential 1 to 4 and it's secured by a federally related loan, there's an extra 120 days, so it's 230 days. Did you know that? Well, there's a new law that says if you're about to have this foreclosure sale, if the owner of the property lists the property with a real estate agent, that adds another 45 days. And even if once you list it, if you get it into contract within before the next deadline, you get another 45 days. So you're adding all these numbers together. It's now 310 days, potentially, between a notice of default and a sale date if you actually list the property and actually put it in escrow. Hopefully, none of you have to worry about that right now. All right. The very last thing, there is a new disclosure, or there are actually two new disclosure laws. Have you noticed? Okay, so I've been doing this since '85, which was the year that the TDS was created. Remember the TDS? Remember in real estate before '85? Who was in real estate before '85? We remember? No disclosures. You have to disclose anything. You know what the motto was then? Let the buyer beware. You're on your own, buyer. So that all changed the year I started. '85, we have a transfer disclosure statement where there's certain things the seller has to disclose. But ever since then, they keep periodically adding new disclosures. But the new disclosures, agency disclosure, for example, natural hazard disclosure, but most of the new disclosures, they don't create a form for them. They just create a new disclosure. So what do we do when there's a new disclosure law, but the government doesn't create a form to do it? I mean, the only forms they've actually created are the TDS, the lead paint form, and the NHD form. But what about these other disclosures? Where do you disclose them? Well, since the government didn't create a form, we created a form called the Seller Property Questionnaire, right? Have you noticed how that form keeps growing? It's because every time there's a new law, we have to add something else. Remember the one we added over the summer? Maybe you didn't know, so I'll remind you, the flipper disclosure. If you're selling a house that you've owned for less than 18 months, you now have to tell the buyer the name of any contractor or handyman you used to do any repair work during those 18 months, and you have to provide any permits you acquired during those 18 months. How would you remember this law? Well, we just added it to the Seller Property Questionnaire. So if you read the Seller Property Questionnaire, you remember these new laws. So, two new laws the governor just signed. Neither one has a disclosure form, meaning we're going to add two more things to the Seller Property Questionnaire. It keeps growing. And hopefully neither of these will apply to you. One of them is, get that, okay, it says specifically, did you know, by the way, if you get your water on your property from a well and the well is destroyed in a wildfire, there is a government program that will for free replace your well with a domestic water storage tank. I don't even know if you knew this. The new disclosure law says if I'm selling a property that has one of these tanks that was given to me because my well was destroyed in a fire, I have to disclose that to the buyer. Hey, buyer, see that nice tank there? You know why that's there? Because we had a fire, blah, 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 blah. So that's a new disclosure. Hopefully it doesn't apply to any of you, but you'll see a new question on the Seller Property Questionnaire related to that. The second new disclosure, once again, I really don't think it's going to apply to you, but it basically says if you're selling a house in an area where the city has passed any type of ordinance regulating use of gas appliances in some way. And by the way, these aren't even necessary. I don't even think these are being challenged in court anyway. The fact that a city says, oh, you have to change out your gas stove to electric. Is that even legal? And there's court challenges to this. But the point is, if there is such a thing going on in your city to that effect, you'd have to disclose it to the buyer. Once again, there'll be a new question on the Seller Property Questionnaire. So that's about it for the stuff that you don't really care about. I mean, now I'll talk about what you really care about, which is this whole buyer-broker stuff. So anyway, I think we'd agree there's not a lot of tremendously threatening bad new laws that just got passed, other than if you're a landlord. I mean, you have to take pictures now, and there's a real issue with the screening fee and the changing the locks. But all of that you can probably absorb. So like I said, it's not a bad year. What I call a bad year is when there are a lot of anti-realtor laws that get passed, and there weren't this year. So that's good, except for the big one, Okay, and there was and I was here. A lot of you probably were here when I was here a month ago, whenever I was, I forget. And there've been more I'll review all that, but there's also been more developments. Okay, first of all, obviously, the background you're all aware of is there were these lawsuits. The lawsuits were settled. As part of the lawsuit settlement, everyone in this room agreed to do two things. And the question is, what if I don't agree to do these two things? Well, you violated the settlement and you can get sued. And the MLS can also fine you. So the two things you all agreed to do were to use buyer-broker contracts and to change the way buyer's agents get paid. So remember, the settlement said, talking about the first one first, the buyer-broker contract, the settlement said you have to use a buyer-broker contract before you can help a buyer. So you can't help a buyer without signing a contract. So the question, of course, is what does it mean to help a buyer? What level of helping triggers the requirement to have a buyer-broker contract? And the real answer is showing. You can't show someone a house without a buyer-broker contract. Residential. All right. But this only applied to residential. Well, the governor just signed a law. So we got the settlement's been in effect since August 17th. By the way, for the rest of your life and my life, we're going to refer to the days before August 17th, 2024 as the good old days. Okay, so 10 years from now, you'll say, remember the good old days? I'll say, yeah, before August 17th, 2024. Okay. Anyway, so on August 17th, the good old days ended. And if you're a buyer broker, before you could show a property, you need a form. Residential only. The law the governor just signed that takes effect January 1st expands that to commercial and land. So if you're working with a commercial buyer, you're working with a buyer who wants to buy a piece of land. Today, you don't need a buyer-broker contract. January 1st, you will need a buyer-broker contract. And this applies not just to the first thing I said applies only to MLS participants. So theoretically, if you're not a member of any MLS, it didn't apply to you. January 1st, the bill that the governor signed applies, first of all, to everyone, whether you're an MLS participant or not. Second, it applies to not just residential, it applies to commercial and land. But it's triggered by writing a contract rather than a showing. So if you're working with a commercial buyer or a land buyer, first of all, today you don't have to do anything. January 1st, you will need a contract, but you won't need the contract to show them the commercial or the land. You'll need it only before you write the offer. So the trigger on the rule under the settlement is showing. The trigger for the commercial and the California law is writing an offer. So it's different deadlines, different types of property, different triggering, but we're going to have the same form. In other words, the BRBC form that we have will work for residential and commercial. It's the same form. The form covers it, so you don't have to worry about getting a different form, but the rules are changed. Do you have a question? Yeah.
Yeah. What's the enforcement mechanism for people who aren't covered under the NAR settlement if they're non-members and then
Yeah.
wouldn't have access to these forms? So is AIR Forms going to come out with something?
Yeah. I mean, so the question is, first of all, to back up for a second, what's the enforcement mechanism against all of you? Well, obviously, you're a party to the settlement, so if you violate the law, you can get sued. And believe me, there are plaintiff lawyers out there looking right now. They're looking for realtors who are ignoring these regulations. There are testers out there. There are testers. I've seen these. They send emails to one of you and says, hey, I want you to show me a couple properties, but I don't want to sign a buyer-broker contract. They're not real buyers. They're hoping that you're going to agree to violate the law, start showing them properties without a contract so they can use that as a basis to sue you. Number two, the MLS, if they find out about this, they could fine you. And to answer his question, number three, the enforcement mechanism for commercial and for non-MLS participants will be the DRE, because this is specifically a DRE law. And they're already geared up for this. They'll have testers. The MLS will have testers, and then there's just testers out there who are just random people looking for lawsuits. So everyone's trying to catch you on this. I mean, don't. So the mechanism is the Department of Real Estate. They're the ones who are going to enforce this. Testers are already out there, legit ones and not legit ones. So we really have to take this seriously. Okay. So we got the new law. This law also says that, remember, there are certain features in this law that we've incorporated already into our forms. One of them is there's a maximum time period, 3 months, right? Listings in California can be 2 years long. Buyer broker contracts can be no more than 3 months. Not 90 days, 91 to 89 days, 3 months. So if you signed one today, October the 8th, it would have to expire by November, December, January 8th, midnight. So it's always 3 months exactly, maximum. Unless the buyer is an LLC or a partnership or a corporation. If that's who the buyer is, how long can the contract be for? As long as you want. 100 years. Sign them up and their descendants for the next 100 years. That since they choose to be a corporation, if they want to buy anything, they got to use you. Seriously, there is no time limit at all if the buyer is a corporation, LLC, or partnership. Otherwise, 3 months for sure. Okay. Like what? I'm not sure what you're asking. Okay, I'm sorry. I mean, first of all, before you answer your question, you cannot have an automatic renewal period in the contract itself. I mean, you can renew it every 3 months for another 3 months. You can keep renewing it, but it can't be automatically built into the contract. Yeah.
For an exclusive BRBC, they have that even if it's exclusive, they can give you 30 days notice.
Right.
I no longer want to work
Right.
with you. Does that
Right.
not apply to the trusts for the 100-year?
No, it would
agreement?
apply to them too.
Oh.
Yeah, that's it. So you're right. He's thinking well that, in other words, even if you have a 100-year one, they can get out of it. Because that is another important feature of the buyer broker contract. I mean, comparing the buyer broker contract to the listing contract, one big difference is the length of time. Another big difference is there's a cancellation period, as he's just pointing out. You know this, right? I mean, in other words, even though it's 3 months, either side can get out of that before then. If it's exclusive, you can get out of it with a 30-day notice. If it's non-exclusive, you can get out of it instantly, which is another difference between the listing contract and the buyer broker contract is exclusive versus non-exclusive. And this is already happening. We're getting feedback on this. You really have an obligation to your clients or to your potential clients to talk to them about this. Like, remember the traditional question when you met a potential client was, are you working with someone already? The new question, of course, is, have you signed a contract with someone already? And if they say yes, the next question has to be, well, was it exclusive or non-exclusive? And they're going to say, I have no idea. And you're going to have to say, then you need to show it to me. And they're going to say, I think I lost it. So you're going to run into this. But the point is, unlike the listing form, the buyer broker contract can be exclusive, which is what you want, which is they're hiring you, you're my agent if I buy anything anywhere, or it could be non-exclusive. If it's non-exclusive, the buyer could theoretically hire more than one agent, and whichever one of them brings them the house they actually buy, that's the one who gets paid. Then you have to explain to them, by the way, if you do agree to non-exclusive, certain things that I do trigger the obligation. Showing you, writing an offer, two different things. But if I do either one of those, I've earned a commission. So you can imagine some buyers are going to have two different agents. Agent number one shows them a property. Then they write the offer with their other agent. They now owe commissions to both of them because both of them did one of the things that triggers the obligation. So if you're ever in a non-exclusive one, you have to explain to your client, you know what this means, right? This means that if you've, that if I find you the house you end up buying, you have to write it with me too, because otherwise you're going to owe more than one commission, which you don't want that. So you have to explain all that. So, and obviously you're going to ask the person whether they had an exclusive or, so what if you meet someone and you say, have you signed a contract with someone? Yeah, I already have an agent. And then he said, but I don't like him. I'd rather use you. And then you know what? Then you ask them, well, is your contract exclusive or non-exclusive? And if they tell you it's non-exclusive, you can say, just fire him and hire me. You're not committed for 90 days. It's non-exclusive. You can fire them today. But what if they tell you, I signed this exclusive contract with this other agent, and but I don't like him. What you're going to say is, well, read the terms of that contract. I think you have the right to cancel, so call me in 30 days. You know what I mean? You have to sort of explain to them. No, I want you to use you right now. Well, you can't have more than one exclusive right now. And then you ask, and then the question is going to be, well, yeah, I had an agent, but I got rid of him. Okay. Did he show you any properties before you terminated your relationship? Either it expires or I cancel my agent. If that agent showed me anything before it was canceled or before it terminated, if I buy one of those houses during the continuation period, they're still protected. They still get paid. So obviously when you take your buyer broker contract, even if the buyer says, no, I don't have a contract with anyone else, you're going to say, did you previously have a contract with someone? Yeah, I did. When was that terminated? Was there a continuation period? Did that agent introduce any properties to you during that period? Then we better exclude them from our buyer broker contract because I don't want you to be paying two commissions. So it's just so much more work that you never had to do before as a buyer's agent, but you have to do this now when you're entering these relationships with your buyers. Figure out, did they sign something before? Has it expired? Was it exclusive or non-exclusive? Were any properties introduced to them during all this time? All these things have to be figured out. What we're hearing a lot about is, buyers, believe it or not, seeing properties with agents without buyer broker contracts, and then when they write up the offer, now they have a buyer broker contract, obviously. So they submit the buyer broker contract to the listing agent, and the listing agent sees, well, you just dated this buyer broker contract yesterday. That means, agent, you were probably helping this buyer without a buyer broker contract illegally. Does the listing agent have any obligation to turn in that? No, you don't. You're not the police. You're not the police. You do what you want. You don't have to. But we're seeing that, where agents, they haven't figured this out yet, so they're showing buyers properties without a buyer broker contract. Then they realize when it's time to write an offer, I better get paid here, so I better get a contract. And of course, the standard offer now, you ask the seller to pay the buyer's agent commission. So you have to tell the seller, you have to give him a copy of the BRBC so the seller sees how much money it is. And that's when the listing agent notices, hey, this is a recently signed buyer broker contract. It's still legitimate. It's not your problem that that buyer's agent was probably breaking the law by not using a buyer broker contract up front. If that makes any sense to you. But we're hearing that. But let's get back to the buyer broker contract. So number one, 3 months or less. Number two, exclusive or non-exclusive. Number three, there's a cancellation right in this contract. Of course, there's the distinction between if it's commercial or land, you actually don't need it to be signed until you write an offer. But if it's residential, you need it to be signed before you show. Before I go any further, what if you're representing a tenant? Are tenant agents required to sign written contracts with the tenant? And the answer is no. This does not apply to the tenant relationship with an agent. But the new rules do apply in that situation because of the next thing, which I'm going to talk about, which is the bigger change, even than I mean, first of all, it's a big enough change, everything I've just said. Having to get contract signs with buyers, that's a big deal. And now having to worry about all these features in these contracts, that's a big deal too, obviously. And of course, the biggest deal on the contract is compensation. I mean, traditionally, I've been working for you for 39 years. I know you guys as buyer's agents never talked money with your buyers. You never did. You didn't have to. It wasn't necessary. You got paid through the MLS. It was very simple. I looked on the MLS. That was my pay. End of story. It's beautiful. Very simple. Once again, the good old days, right? But that's gone forever. So now, how do I get paid as a buyer's agent? In other words, if the listing agent's not going to pay me through the MLS, how am I going to get paid? Well, before we even get to how you're going to get paid, the question that comes before that is, how much are you going to get paid? And that's what your buyer has to approve. In other words, hopefully, it's probably not going to be a situation where the buyer is actually going to be the one to pay you. Chances are the buyer is not going to be bringing money into escrow to pay their agent. But the buyer still has to agree to that money. So your buyer broker contract, commercial, residential, I don't care, there has to be a number there about compensation. And that is the most you can get. So you and the buyer agree they're going to pay you 3, 2.5, whatever it is. You can't get paid more than that. You can get paid less than that, but you can't get paid more than that. So the buyer and you are sort of agreeing right up front before you even start doing anything what your value is, which is a new concept that you've never had to deal with before, which is explain your value to a buyer. You've always had to do this with sellers. You didn't have to do it with buyers. Now you do. So we have this paragraph there, and it can't be a range. Oh yeah, I'm going to get paid between 1% and 5%. It can't be, I'm going to get paid whatever the seller is willing to pay me. No, you have to have a number. So we got that. All right. But the next question is, so we've got the buyer broker. I understand the concept of the buyer broker contract. I put a number there. The buyer agrees how much I'm getting paid. You know what I think, what we're hearing, by the way, on the hotline, I don't know about you guys, is that buyers are going along with this. Buyers are okay with this, and buyers are signing this, and buyers are agreeing to pay you the number you want to get paid. I mean, my fantasy what was behind all these lawsuits, remember, is the unsupported belief that realtors were getting paid too much. That was the theory of these lawsuits. The theory of these lawsuits was that the buyer had no input into how much their agent was getting paid. I mean, the listing agent was determining the buyer's agent's compensation. The buyer had no input. Therefore, those commissions for buyer's agents were probably higher than they should have been. That was the background of these lawsuits. But you know what? I think the potential is your commissions could go up. I mean, for the first time, you're actually sitting talking to your buyers about all of the things you do for them. And the buyer's reaction might be, wow, you're going to do all that? How much do you want? 6, 7, 8, 9%? What's the right number? I mean, it never probably occurred to the buyer how much you were getting paid. And now that they think about it, I mean, this is your opportunity to impress them with your value. Anyway, the point is, you come up with this number. So the buyer agrees, yes, you're worth that number. You and I agree, you are absolutely worth that number. But then the buyer says, but I don't actually have that money. I can't afford to pay you that money. I barely have the down payment. I literally robbed a bank for the down payment. I have no more money. So you and the buyer agree to your compensation, but the next question is, how do I arrange to get that money? The traditional way was you didn't have to arrange anything. It was automatically paid through the MLS. Well, that's gone forever. So the next question before I go any further is, well, okay, so the settlement says listing agents can't offer compensation to the buyer's agent through the MLS. So the next question logically is, well, can listing agents still offer compensation to buyer's agents outside the MLS? And when the settlement first happened, we thought that was going to be okay, but there have been further developments. It's called the Federal Department of Justice. They are taking a very strong position that broker-to-broker compensation itself is the problem, whether you use the MLS or not. So we are waiting for the final settlement, and we're waiting for the DOJ to, make their position clear and try to influence the settlement. But we hear what the DOJ is saying, and we hear what other plaintiffs' attorneys are saying broker-to-broker compensation is, it doesn't say that in writing anywhere, but that's not a good thing. So C.A.R. basically took the position that we're not going to facilitate that at all. None of our forms refer to that. So I'm advising you as your lawyer to don't think about listing broker paying buyer's broker. Which leads to the question is, in the good old days, as a buyer's agent, the listing agent paid me. Who's going to pay me now? And the answer is the seller, which was actually the true anyway. In the good old days, the seller still paid you. They just gave extra money to the listing agent so the listing agent could give some of that to the buyer's agent. It was still the seller paying. Now, we're cutting out the middleman, right? Instead of seller paying listing agent to pay buyer's agent, just seller pay listing agent and seller pay buyer's agent directly. So you've noticed on the listing form now, there used to be two blanks for compensation. One was, what's the overall commission and how much of that are you going to give to the buyer's agent? Remember those two numbers? Well, and do you remember back in the good old days, the listing contract never said how much the listing agent was going to get paid. It said how much the total commission is and how much of that goes to the buyer's agent. Well, how much was the listing agent going to get paid? Remember, you had to figure that out for yourself? But if you went to first grade, you could do that because the overall commission would say something like, I'm paying the listing agent 6%, and then they're going to offer 3% to the buyer's agent. How much is the listing agent going to get? Well, let's see, 6 minus, okay, you can figure it out. But remember, there wasn't a blank on the listing to say, what do you get? Well, now on the listing, that's all it says. The only number there is what you get. Not a number you're going to share with someone, just how much are you going to get for you? Number. So sellers are going to negotiate directly that number with their listing agents. Okay. So where does the buyer's agent get paid? So you're explaining to your sellers, hopefully you're already doing this, that, okay, remember in the good old days how last time you sold a house, you paid your agent like this big number and they shared it? In other words, you were paying both agents. You were giving extra to your listing agent. Well, now, did you notice when you listed with me, I didn't charge you the same amount I charged you the last time 10 years ago? Because I'm assuming those of you that are taking listings now are no longer getting 5 or 6% listings. If you are, good for you. But I'm sure the average seller figures out, okay, so you're not paying the buyer's agent, so yeah, I'm going to just pay you for you, which is this smaller number. But then you're going to remind your sellers, of course, there is still a buyer's agent there, and they're still going to need to get paid, and they still want you to do it. So rather than you paying me extra so I can pay them, did you notice you're paying me less? Don't get too excited, because the buyer's agent is now going to ask for that. The buyer's going to ask for that directly in the contract, because the buyer is the one who's agreed to pay their agent, and now they're just going to ask you to agree to pay that as a closing cost. Because this is the way real estate has always worked for 100 years. The idea is there's a purchase price and then there are closing costs. Purchase price doesn't cover everything. Purchase price doesn't cover commissions, escrow fee, title fee, NHD fee, transfer taxes. There have always been fees that need to get paid. And most of these are buyer fees that need to get paid. And it's always been understood for 100 years that rather than the buyer bringing all this money into escrow to pay for the closing costs. They're going to build it into the purchase price, and it's going to be financed. And the seller's going to agree in the contract. Yeah, I'll pay your escrow fee. I'll pay your title fee. I'll pay everything. It's understood that you offered them enough money that it makes sense. So the way nothing has really changed. I mean, the commission has always been part of the closing costs. I mean, think about it. As a seller in the past, did the seller bring money into escrow to pay your commission? No. Where did the seller get the money to pay that anyway? From the buyer's proceeds anyway. Sellers never bring money into escrow. Listing agents have always gotten paid by the buyer, if you think about it. Listing agent, I mean, yeah, I sign a listing to pay you this money. Okay, great. Does the seller ever go to the bank to make a withdrawal to pay their agent? No. They wait until close and they use some of the buyer's money to do that. It's always been done this way. Buyers bring in all the money and this money gets divided out to everybody. It's just slightly structured differently. Rather than extra money on a listing contract, it's less on a listing, and then the buyer asks for it directly in the offer. And I think when people hear it that way and understand it that way, it makes sense. It makes sense that this sounds like such a big change, but it's not really that big of a change. It's still buyers not wanting to finance everything, and sellers are still not bringing money into escrow. Seller says, why should I pay the buyer's agent? You've always paid the buyer's agent, and you're not even paying him anyway. You're not going to your bank to pay the buyer's agent. You're just going to divert some of the buyer's money to their agent, just like you're going to divert some of their money to me. That's what you do, seller. You tell the escrow company, divert some of the buyer's money to all these other people. I mean, that's really nothing has really changed if you look at it that way. That's the way I think you need to explain it to your clients. And I think they sort of, my experience is so far so good, people are sort of understanding it when you do it, explain it that way. So anyway, so the concept is, first point number one, listing agent, don't do broker to broker compensation. Referral fees are fine. You can still pay each other referral fees, no problem. You don't need a buyer broker contract to collect a referral fee. Similarly, if you're buying new construction and it's a situation where the builder just wants you to give them the referral and they'll pay you a fee, you don't need a buyer broker contract for that either. Okay. But anyway, so the concept is my buyer has agreed to pay me. So I want the seller to agree to credit me that money. We're going to check the box, paragraph 3G3. So 3G3 says, hey, seller, I'm asking for one more credit in addition to all the other credits I'm asking for, and this one is money, and then you attach the SPBB form. Now, what did that stand for again? Right. Super peanut butter and bread. You'll be happy to know that form is going away. I'm very happy about this because it confuses people today. What's going to happen December, so not yet, I'm sorry, 2 months from now, that form will go away. So 3G3 in the contract is where you're going to put the money in. So today it's like a two-step process. You have to check a box to say, I want you to pay the commission I owe my buyer, but then I have to give you another form to tell you how much that is. Wouldn't it be simple? Just the same place I want you to pay, tell you how much. No more of this SPBB form. I'm very happy about that. You got to deal with it for 2 more months, but it'll just be right in the contract how much it is, how much you want. And then the question, of course, is that we're hearing and dealing with is, and I know the frustration you have. The frustration you have is my whole life up until now, in the good old days, I knew as a buyer's agent, before I even started work on a transaction, I knew exactly what my pay was going to be because that was in the MLS. But now I don't know. And that's frustrating because what if I write the offer and we're asking the seller to pay that compensation, the seller counters, I don't want to pay it. In other words, I want some surety. I want some comfort. I want to know how much I'm going to get paid. So this is, you no longer have this, right? Well, on the one hand, you do have it because you have a buyer broker contract. You could say, well, I know exactly what I'm going to get paid because the buyer has agreed to pay me. And if the seller won't pay me, the buyer still has to pay me. So I know what I'm going to get. But then you know in the real world that if the buyer agrees to pay you 3% and you ask the seller to pay 3%, the seller counters, you only want to pay 2%, now what? Well, the buyer owes that extra percent, but the buyer says, I don't want to pay it. I can't pay it. Now what? You have two choices, right? Number one is be a saint and reduce your 3% back to 2%, and everybody's happy, but you only get 2%. Or be the mean person and say, well, buyer, I guess you're not going to buy this house. And you have the right to do that because your buyer broker contract says the buyer has irrevocably assigned to you through escrow your full commission. You present that form to the escrow company, escrow cannot close without you getting paid in full. Of course, then the buyer is going to look at you and say, so you mean the only reason I can't buy this house is you? And you're going to say, yes, it's exactly right. Because I want to get paid what I should get paid. Just like you at your job. Don't you want to get paid what your boss agreed to pay you? Are you going to let them cut your pay this month because they feel like cutting? No. You and I agreed on my value. So this is frustrating because then so what people have been trying to do and the thinking has been, well, is there any way on the buyer's side, can I just contact the seller or the seller's agent before I even make the offer to see how much they're going to pay the buyer's agent? And on the listing side, people say, well, can I advertise that we're willing to pay the buyer's agent, 2%, whatever, 2.5%, whatever? Well, I have two responses to that. One of it is that the Department of Justice doesn't even like that. They're saying what we don't like is whether it's the listing agent or the seller, we don't like someone on the seller side determining how much the buyer's agent gets paid. So in the old days, the listing agent advertised, we're going to pay the buyer's agent whatever. So if you just change that to now the sellers start advertising, or you guys start saying, my seller will pay, it's really the same thing. It's the listing side coming up with the number that people are going to get paid. They're sort of setting the field there. And that's what the fundamental problem is in the eyes of the DOJ and the plaintiffs' attorneys out there. So what we're saying, the mindset should be, on the listing side, if you want to indicate to the other agents out there that you're willing to pay their compensation, you just advertise seller is absolutely willing to consider his offers requesting seller concessions. Just put it out there. That gets the message across. That gets the message across that they understand the new reality. They're willing to, every seller in the world is going to consider that, right? And if I were a seller and a buyer called me up and said, or I was a listing agent or a seller, and the buyer called me up and said, will you pay my agent 2.5 or whatever, says, I would say, I'll pay your agent whatever they want if the offer is good enough. If the offer is not good enough, I probably won't pay your agent anything. You know what I mean? If you offer me $1 million over the listed price, I'll pay your agent 10% and I'll buy him a Porsche. I don't care how much you want me to pay your agent. As a seller, what I care about is what is my net? If I'm a seller and I get 4 offers, one of them asks me to pay the buyer's agent 1.5, one says 2, one says 2, and one says 3. So the different offers are asking me as the seller to pay agents different amount. If the one that's asking for 3% is going to result in me getting the highest net, I'm going to go with that one. I don't care how much the agent's getting. I care how much I'm getting. So it's like, why even think about this whole idea of how much the agent is getting? You write a good enough offer so that the seller is going to end up with, because a typical offer, you ask for the seller to pay for the escrow fee and the title fee and the transfer taxes. So you're just asking for credits. Why are sellers okay with that? Because they figured out that based on your price, subtracting those things, I still end up with the number I'm looking for. You know what I mean? So when I see people sell it, I mean, someone writes an offer today, I want the seller to pay my agent, 3%, and the seller counters, I only want to pay your agent 2%. What the seller is really saying is, you didn't offer me enough money. I mean, the buyer's response to that should be, I'll increase my price by 1%. Sellers don't philosophically care how much they're paying your agent. I think we got to get away from that mindset. I don't think I know everyone's not rational, but a rational seller doesn't care how much you're asking them to pay their agent. And I think it's pointless to try to contact the listing agent or the seller before you write, how much are you willing to pay the agent? My answer would always be, write me an offer. I'll pay them whatever they want, if it makes sense. I'm not going to, why would I predetermine one particular closing cost? I'm going to commit to you right now, I'm going to pay your agent whatever. I'm not going to commit to that. Why would I? What would be the point of that? And what would be the point of you actually asking on the buyer's side? How much are you willing to pay my agent? Write me an offer. I'll pay your agent whatever they want, if it makes sense. Otherwise, I won't pay your agent anything. Or unless you increase the price to the number I want. I'm looking for a net here. I'm looking for what am I going to walk away with? How we structure that, we'll figure it out. And I think also, I mean, and the way you explain this to sellers is, this isn't increasing your cost. I didn't used to have to pay the buyer. Yeah, you did. You just paid them indirectly by giving the listing agent extra money. Now you're saving money by paying your listing agent a lot less than you used to. But there's still a buyer's agent who wants to get paid. And if you start saying, start sellers saying, I'm not going to pay the buyer's agent, you're going to lose offers. If you can have, first of all, why would you rationally say, under no circumstances will I pay the buyer's agent? Even if it's the best offer, even if it's the best net you get, you have a philosophical problem with paying the buyer's agent, even though you've always paid the buyer's agent, even though actually you've never paid the buyer's agent, the buyer pays everybody, because all the money that everybody gets in real estate, including me, including Cutco, anyone who gets paid, I mean, I get paid indirectly I get paid from you, and where do you get your money? From the buyers who buy, you know what I mean? Buyers pay everybody. Everyone in this room, the staff at the Bakersfield Association, you're getting paid by buyers. Buyers are paying everybody. Where does the money come from in real estate? Buyers bring money into escrow, and that results in the whole real estate industry getting paid, including the taxes. I mean, you got to look at it that way, and I think we don't focus on this whole, it's big change here about who's paying who. No, buyers are paying everybody. And it makes sense that agents get paid. If I were a buyer, of course, I who know what I'm doing, I want the best buyer agent out there. As much as I want them to get paid as much as they possibly can, because, I mean, another thing behind these lawsuits. So the two fundamental things behind these lawsuits are the listing agent shouldn't determine the buyer's agent compensation. And the idea of these lawsuits is, the reality was, when the listing agents throw the number out there, that's the number. No one ever negotiates that. So now, of course, the big deal is the listing side doesn't determine the buyer's agent compensation. But the other big thing is the new rules allow buyer's agents to negotiate on price. And you don't like this, but it's always been true on the listing side, and it's never really been a problem. I mean, there have always been listing companies out there who try to get business by offering their services for a lesser amount, right? Everyone from Help You Sell to Purple Bricks, I mean, it's always been a thing. Well, now it could be a thing on a buyer's side. I mean, any buyer's agent could try to get business by going around to people and say, listen, hire me. I'm not very good, but I'm cheap. I mean, you're not used to this concept. I mean, up until in the good old days, pretty much every buyer's agent got paid the same because the listing agent determined it. So if a listing came up there were offering 3%, they were basically saying whoever the buyer's agent is, whether it's really great agent who's done 1,000 deals in 25 years or first-time agent hasn't done a deal ever, they got paid the same. But now theoretically, first-time agent who doesn't have any deals can try to get business by getting a lower number on the buyer broker contract. And then we'll see how that works out. You know, how's it worked out on the listing side? Discount listing agents tend not to do very well. But the point is, it is an issue. It is negotiable. And that's the fundamental thing that was behind these lawsuits. The idea that buyers should have the ability to negotiate their own agent's compensation. I mean, me, for example, who know what I'm doing, I would hire, if I was buying a house in Bakersfield, I'd hire one of you really good top agents, and I'd want to pay you as much as you get what you pay for. You understand that. But I mean, that is a possibility. There could be price negotiation on commissions on the buyer's agent side. That's competition. I think that's not something to be afraid of, and that's something I think you'll all deal with. Since this started, August 17th, we're almost 2 months into it. With all these, I've mentioned glitches some people don't understand, but basically deals are closing. And if you're experiencing this, deals are closing and the commissions are about the same amount they've always been. Which means the rate of commissions that you were always getting paid was probably the right number anyway. You can negotiate higher. I don't think you get paid enough. And I say this sincerely because your job gets harder every year. I mean, when I started 39 years ago, the purchase contract was 2 pages. Your clients actually read it and understood it. When's the last time you had a client that read all 17 pages and understood them? You have to deal with all that, all the other forms. I love to talk about this. When I started, the purchase contract was 2 pages and there were like 10 other forms. The entire forms library was like 30 pages. How many forms do you think there are on zip forms now? 250. How many pages total? Thousands. And you're supposed to know all these forms. You guys, your standard of care is to understand the C.A.R. forms. That's a big job. You're not getting paid enough for that job. But anyway, the point is it's a market, it's negotiable, you get what you negotiate. But so the real new things I've been telling you is only that there's a new buyer broker contract. You're aware of that. There's this new law that kicks in January 1st dealing with the commercial and land. By the way, getting back to tenants. So I said you don't need a contract to work with a tenant. But if any of you are tenant agents, if any of you work with tenants, how have you got paid in the past? Typically, the lease listing agent offered you compensation on the MLS, right? I mean, but they can't do that anymore. So even in the lease situation, the MLS cannot be used to offer compensation. So the question is, if I'm an agent today and I'm working with tenants to help them find a rental, how am I going to get paid for that service? And I can get paid by it's still okay to get agent to agent compensation is still okay in the rental situation. But how do I go about arranging for that if it's not in the MLS? So what we're saying is we recommend you use the tenant form. We do have a tenant representation form, not required, but use it. On that form, the tenant agrees to pay you. And just like the buyer, they don't want to pay you. So you can still get the landlord or their agent to pay. We have a form for that. LCA, lease compensation agreement. So you would give that to, what I would do is I would either give it to the lease listing agent and say, please have your landlord sign this. Someone's going to sign. I mean, I'm assuming that they still, I mean, if they're not going to pay, you're not going to bring them a tenant. So the point is, even though this doesn't directly apply to the lease situation, it does sort of indirectly apply. So you still have to think about, if any of you guys work with tenants, you'd have to, it is different how you get paid. At least there's a contract there. There's a specific contract. Another issue, a couple more issues. One of them is we're getting so many questions on this and about open houses and unrepresented buyers. So remember the first thing I said, one of the two fundamental changes is you can't show a property to somebody without a contract. Did you know there's an exception to that? There's a really big exception. The big exception is if you are the listing agent. So, I mean, if I'm just a random agent out there and some buyer wants to see a house, I cannot show them the house without a contract. But if it happens to be my listing, I can show it to them without a buyer broker contract. So if I'm a listing agent and I get a sign call or something, a buyer just calls me up. Hey, can I see this house you got listed? First question I'm going to ask them is, sure, do you have an agent? No, I don't. Well, then hire me. I'll be your agent. I'll be a dual agent. Perfectly okay. Always been legal. Will always be legal. So hopefully they sign a buyer broker contract. Now you're representing both. So you have a listing contract with your seller client. You have a buyer broker contract with your buyer client. Perfectly okay. But what if this buyer says, actually, I want you to show me the house, but I don't want to hire you as my agent either. I don't even want an agent. Or maybe I don't want an agent yet. I want to see the house before I decide if I want an agent. Well, your response to that, first of all, I would talk to my seller at the time that I took the listing. And I'd ask my seller, how should we deal with people who don't have agents? Some sellers might say, ignore them. If they don't have an agent, I don't even want you to show them the house. Let them get an agent. But I suspect the average seller is going to say, well, go ahead, show it to them. And you're allowed to do this. You're allowed as the listing agent to meet this unrepresented person at the property and show it to them. But remember, this is the person who says they don't want to hire you as their agent. They just want to see the house. What I would do in that scenario, though, is before I showed it to them, I would give them this form. It's called the BNA, Buyer Non-Agency. And what this form is going to says is, you understand, buyer, that you are being shown a house, you're being assisted by an agent who is not your agent. They are the listing agent. This prevents them from coming back and saying, well, number one, this agent broke the law. They showed me a house without making me sign a buyer broker contract. And the response is, they had the right to do that because they were the listing agent. And then they say, well, I assumed when they showed me the house that they were my agent. And since they were my agent, they didn't do a good job of representing me, blah, 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 blah. And your response is going to be, you signed a BNA form where you acknowledged that I was not your agent. So you're okay. We stand behind this BNA. People say, I'm worried about this BNA, that they're going to say that we created an agency relationship, blah, blah, blah. We stand behind the BNA form. If the buyer signs that form, they cannot come back later and say, well, you were my agent and you owed me these duties and you didn't do it. No, you signed the form. So once again, you can show properties to people who don't sign a buyer broker contract if you are the listing agent. And when I say listing agent, I mean anyone in the listing brokerage. It doesn't just have to be the agent whose name is on the listing. You can do that, make them sign the BNA, and you're good. Then the next question is, and tell me if this is even happening, or I'm not even sure this is ever going to happen, but what if this unrepresented buyer, once you show them the house, and they said, well, I want to write an offer. You say, knock yourself out, write an offer. Could you help me with this offer? Do you want to hire me as your agent? No, well, then I'm not going to help you write the offer. But then they say, could you give me the C.A.R. form so I can write the offer on the C.A.R. form? And you know something? You might want to do that. You and your seller may say, well, if they're going to write an offer, it's probably better that they use the C.A.R. form rather than make up their own form. So you and your seller can make the decision to give this person who's not your client C.A.R. forms. Do you have to do this? No. But you can if you want to, if it's in your seller's best interests. If you and your seller think, well, yeah, let's see what they have to offer, and since we'd rather they write an offer on the form we actually understand, so let's give them the C.A.R. form. Do it. You can do it. So they write the offer, and it's the best offer, and the seller accepts it. And you say, oh, great. Now I got to do this whole deal with this buyer. I got my own client, then I got this other side who doesn't have an agent, so they're going to be asking me all these questions. Plus, I'm going to have to meet them at the house to let the inspectors in. That's a lot more work for me. Which is confusing everybody. There's a line on the listing contract now in the compensation paragraph that says, how much extra money is the listing agent going to get paid if the buyer is unrepresented? Let me ask you guys, in the last month and a half, has this happened to you at all? Have you ever gotten an offer? Maybe this is a non-issue. I'm not sure this is going to be a thing where buyers make offers without agents. I maybe doubt it myself. But the point is, we've addressed it to deal with it. But I think there's a bigger issue, and that's open houses. I think all these years in the good old days, you guys have been kind of cavalier about open houses. Because I know how open houses work. I like to go to open houses myself just for fun, believe it or not, and because I like the free food and stuff. Anyway, but the point is, I think what happened in the good old days is buyers walk into open houses, not buyers, visitors walk into open houses, the listing agent's there, and the listing agent shows them the house, thereby creating an agency relationship. When you didn't really think you didn't think of them as your client, and they probably didn't think of you as their agent. But once you start showing someone a house, that probably creates an agency relationship. So I'm actually happy about the fact that nowadays you have to think about that. Nowadays, when you're hosting an open house and some drunk stumbles in the front door, somebody just walks in, you have to start thinking about this now. You have to start asking them. I'm sure you probably already did this, but you really have to ask them, do you have an agent? No. Or, yeah, but they're not with me. Either way, you cannot just show them the house if they won't sign a buyer broker contract. If they've already got an agent, they're definitely not going to sign a buyer broker contract. They don't want to hire you too. But even if they don't already have an agent, they may not want to just hire you right now as their agent. So you're going to have visitors who come into open houses, just like you always have, and they don't want to just walk around on their own. They want you to show them around and answer their questions. Well, you can only do that in two situations. One of them is they actually sign this buyer broker contract. But remember what I said a second ago? There's an exception to that. You can show someone a house if you're the listing agent. But once again, we have this issue of, I don't want them to think by me showing them the house that I'm their agent all of a sudden. So we have a form, which is very similar to the BNA, called the Open House Non-Agency Sign-In Sheet. They're pretty much interchangeable, to tell you the truth, the BNA and the OHNA. What I would do, if I were you, if I had an open house, instead of my normal sign-in sheet, I'd have either in addition to that or replacing that with the C.A.R. open house sign-in sheet. So now when they sign it, not only are they doing what you want, which is giving you their contact information, but they're also agreeing that they understand that if this nice agent in this house answers my questions or shows me around, they're not my agent. They're doing it on behalf of their seller. So it's just like the the BNA. It's giving you the safety. You can safely help this unrepresented person without creating an agency relationship and without triggering the obligation that they have to sign a buyer broker contract. So now we have one more burden on you at open houses. Now you have to think more. You have to think about, who is this person? In what capacity am I dealing with them? So what if this open house visitor doesn't want to sign anything? I don't want to sign anything. It's an open house. I'm not signing anything. you can't really help them. I mean, you can give them the flyer, you can answer questions that are on the flyer, you can give them the donuts, give them the, the water, be nice to them, even walk around with them, make sure they don't steal anything or break anything, but you can't really assist them. You can't show them, you can't answer their questions, which is probably the way it's always should have been. In the past, I would have said you always should have done it so you don't create these inadvertent agency relationships. But now it's really important because not only do you not want to create these inadvertent agency relationships, you don't want to be accused of showing them properties without a buyer-broker contract. You're allowed to show them a property with a buyer-broker contract if they acknowledge that you are the listing agent. So we have a form for this. Okay? Is it making sense? Those are the big things I really wanted to talk about. I mean, what we're waiting for now is the final settlement. What's kind of weird about this whole thing is the August 17th deadline to make the changes kicked in before the settlement was finalized. Someone said, why do I have to do all this? The settlement hasn't even been finalized. Because the terms of the settlement were you had to do it by August 17th, whether it was finalized or not. I mean, theoretically, what could happen, which is not going to happen, don't get your hopes up, is that in November they throw out the whole thing. Forget this was a big mistake. We're going back to the good old days. That's not going to happen. The judge has already said, preliminarily, I'm going to approve it. What we're just waiting to hear from is the Department of Justice. And it looks like they're going to approve the settlement. But we're going beyond that to understand that we know what their real position is. They may actually say the settlement isn't sufficient unless it clearly makes more clear about no broker-to-broker compensation, but we're advising you not to do that anyway. But what I'm really saying is the Department of Justice and the attorneys who like to sue realtors are already saying that we don't like the whole idea of sellers advertising in any context how much they want to pay the buyer's agent. And as what I've tried to explain to you is I don't see any need for that anyway. If I were a buyer's agent, I know, yeah, I'd like to know, oh, good, they're going to pay me 2.5 or whatever. But really, why would they commit to that? Why would a rational seller, well, I want to get interest in the property? Then just say you're willing to consider concessions. Of course, every seller wants interest in the property. I think we're all sort of adjusting to this, and I think pretty much, in my experience, sellers are sort of understanding this. If you explain it to them right, I think they're all going to understand it. And I think this is going to be a smoother transition than maybe you were worried about or expecting. And so far, so good. You tell me if you're running into big problems. This is the time when we want to hear from you. We already heard the SPBB is bad, so we're getting rid of it. Well, that was the first feedback we got. You guys are out there doing this. You're representing buyers and sellers. You're trying to do deals. You're trying to get paid. If you are running into obstacles that are preventing you from doing deals and getting paid, you need to tell us. Is there something we need to do? Are there form changes we need? Are there things that will help you talk to your clients that you need? I mean, is it okay? I mean, are open houses a problem? Is anything a problem? Because there are testers going to open houses too, I hate to tell you. They're going to open houses trying to get you in trouble. They're trying to get you to show them the property without a buyer-broker contract. So you're not going to do it unless you're the listing agent, in which case you can do it, but then to protect you, make sure they sign this.
What about if you're doing an open house
Yeah.
that doesn't belong to your broker's
Yeah.
office?
Yeah, that's a great question. If you're doing an open house and it's not part of your brokerage, obviously, by definition, you're not the listing agent, which means by definition, you cannot show this person the property unless they sign a buyer-broker contract. So my advice to you is if you work for company A and your friend at company B wants you to sit an open house for them, just think of yourself, you're there as just a random potential buyer's agent trying to get business, which you're allowed to do. When people walk in, start talking to them about what they're looking for, and you can try to get their business, but you can't help them with this house. I mean, you can give them a flyer, but you can't show it to them at all. Whether they sign that open house sign-in sheet or not, because that open house sign-in sheet doesn't apply because you're not the listing agent. So if it's not your listing, don't help them. Give them the food, give them the coffee, give them the donuts, give them the flyer, but you can't really go beyond that. Yeah.
I want to ask a question that may be slightly off topic, but you may know more
Okay.
about this than any of us. Is there any litigation in the works nationally that would outlaw forever a dual agency?
That's just not going to happen. It really isn't. The only possibility, which I don't think is going to happen either, would be eliminating single agent dual agency, which would mean if you had a listing and you had a buyer, you'd have to refer the buyer to someone else in your office. But I don't even think that's happening. But eliminating dual agency in general, we're saying agents from one office can't work on the, that's just not going to happen. There's nothing about that. I was worried you were going to ask me about clear cooperation because I don't know about that. And that might be overturned. But dual agency is not going to go away. And I don't even think in this state, I see no push at all to get rid of single agent dual agency. So I don't think that's an issue right now.
Back to open houses.
Yeah.
Is there a retainment schedule for the sign-in sheet? So we are not the listing agent, so of course we don't put it in the file.
Right.
So if we're of the same brokerage
Yeah.
and we have the sign-in sheet,
Yeah.
is there a retainment schedule for us to have to keep it for proof?
I mean, the whole idea of this open house form is no, the DRE doesn't care. This is to protect you. All the open house form does, it protects you from someone coming back and saying, well, I assumed she was my agent. The way she was helping me, I assumed there was an agency relationship. It defends you from that. No, you don't need to keep it. You keep it for your own defense, right? And by the way, a question that's coming up, you guys haven't mentioned it, but sometimes people, if they sign that sheet, they want a copy of it, right? So you know how we have that sheet, there's room for like 7 people to sign? What if they want a copy of it? You may have to bring a whole bunch of them. Print out a whole bunch of these so there's one per person. Or they'll try to take a picture of it. But you don't want to take a picture of it if it has people's personal information on it. So maybe this is more work for you, which I hate to say, but you may have to start bringing a big stack of open house sign-in sheets to your open houses. Remember, this is for your safety. This is to protect you from buyers claiming that there were, So do we have Zoom questions? That's a good, yeah.
We do. The first question is, are there going to be any changes to capital gains?
We are hopeful. Obviously, what's being asked is, when you sell a house, you have a potential to pay a capital gains tax. If you're married, the first $500,000 of profit is tax-free. But prices have gone up so much that it used to be no one worried about this because when that was passed, the average sale price was like $200,000. Now the sale price has gone up, but that hasn't gone up. So you or yourself are probably running into situations where people are selling houses that have gone up in value more than $500,000 from when they bought it. Or if you're single, it's only $250,000. So we'd love to get that doubled. And there's a proposed law that would do that. Nothing's going to happen until the election. But after the election, whoever wins, we don't really see a reason why that wouldn't go through. So I'm optimistic. That would be nice. I don't know anything more than that, though.
I think you've answered this before, but can you send a listing through the MLS to a buyer without a buyer broker agreement?
When you mean send a listing, what do they?
So like automatic emails. So if you've got them set up on like a client portal.
Oh, I see. Yeah. Now I see what you're saying. In other words, remember the first question I addressed is what you have to have a contract before you can help a buyer. Is setting up a system where you periodically just send them, I guess, new listings or whatever. Is that the type of helping I can do without a buyer broker contract? Yes. You know what the only, and you remember I said what the triggering event is writing an offer on a property? Well, hopefully we're going to get this clarified in the final settlement in November, but there's language in there that implies that even before you show a property, if you sort of focus on a particular property with a buyer, like do a CMA for this particular property, that even before you show it, that might trigger the requirement to have a buyer broker contract. But just sending them a feed of properties that are available or that they might be interested in, just doing that, you can do that without a buyer broker contract. Anything else? You guys are a lot calmer than the last time I was here. It's working out, yeah.
Can you further explain clear cooperation?
No.
Association has a ruling that does not agree with yours.
Yeah. And in all honesty, the way that's an association question. And the way the legal department at C.A.R. is set up is people like me answer member questions. We have attorneys at C.A.R., which he can call, that would gladly address that issue, whether your policy is okay or not okay. I just can't even address it if I want to. In other words, it's an MLS related question.
For now, today, what's the date today?
October 8th.
October 8th. Clear cooperation is in effect for our association until otherwise stated differently. There's some talks about some other stuff. We're not there yet. So we can only control what happens today. Tomorrow's not here. Let's not worry about it. But we will be communicating clearly if something changes in regards to clear cooperation and having a home that is listed be put on the MLS immediately. So as of now, there are no changes to our clear cooperation rule here at our local association. So continue business as usual, please.
And what could happen is there could be litigation on this where the courts will step in and say, okay, NAR, you have to change your clear cooperation policy, and that would trickle down to Bakersfield and everywhere else. But that hasn't happened yet. There's no court case that's been resolved. It's just NAR hasn't changed its policy. So like, deal with him, deal with your leadership here, but it's not a hotline type legal question. Yeah. I'm glad. They might have different rules. Yeah.
Follow the rules of my association in
Fo-
Los Angeles.
Follow the rules of whatever association your listing is in. Yeah. That's
Well, my
confusing.
listing is here.
Then follow your rules
And
here.
so I don't list it or I don't clearly cooperate, whatever. the
Talk to
words are.
them, talk to him, talk to, yeah.
If they say no, then you don't have to. If we say yes, then you have to. So you have to for us, and you may not have to for them.
Okay.
Yeah. Yeah. Yeah, that's a confusing thing, is there are different rules, just like coming soon. Different associations have different rules on coming soon too.
So the rule with clear cooperation is once you advertise it publicly, it has to go in the MLS within 1 business day. Okay, so that could be a flyer, it could be a sign telling another brokerage about it. So it's just publicly advertising. As long as you don't publicly advertise it, you can tell everyone in your office about it, but once you publicly advertise social media, then it has to go in the MLS within 1 business day.
Any more non-clear cooperation questions? He needs the mic over here.
There you
As to the Department of Justice,
Yeah.
Attempting to reach in.
Yeah.
It would seem that sellers are not a party to the settlement at all. And how can they form a basis of jurisdiction to dictate what sellers can or cannot do.
Well, it still affects agents though. Sellers can't do things without an agent.
Sure they can.
Like what? What are we talking about, for
They
example?
can tell their agent, I want to offer a commission in a specific amount, and an agent is obligated legally to do what they're
Yeah,
directed to do.
now I see what you're saying. The point is, sellers can't do whatever they want. Sellers have to abide by federal law, just like fair housing. Some sellers think I can sell to whoever I want. If I want to only sell to people of this nationality, if I want to only sell to people who don't have kids or have kids, it's a free country. I'll sell to whoever I want. And that's not true. You absolutely cannot do whatever you want. The federal government has the jurisdiction to limit how you advertise or how you whatever. The federal government can do that. So yeah, it's under the authority of the antitrust laws, the federal government can do a lot, just like fair housing. So we do have to deal with that.
I have a question in reference to offer presentation.
Yes.
Now that you sign a buyer broker agreement and you negotiate your commission directly with the buyer,
Yeah.
when you go to present your offer, there may be a bias by the listing agent based on what they're charging the seller. What do you have as a buyer's agent in reference to asking, or what right should I say, to present your offer directly to the seller, obviously with the listing agent present?
Yeah.
And if the listing agent says, no, you may not, what documentation can you ask for proof that you made that request?
Yeah. In other words, forgetting all this new stuff, this has always been an issue forever. In other words, for some reason, the buyer wants to present their offer directly to the seller. You can make that request. And the question is, the listing agent should be communicating that to the seller. And so you're saying, what documentation are you entitled that the seller got this request, you mean? Yeah. There's no particular form, but you are entitled to a response. Buyers can always contact sellers directly, whether the agents want them to or not. But you can certainly request it to be present at the showing or something like that. You can request whatever you want, and the listing agent has to pass this on to the seller, and there's no magical paperwork that you're entitled to, but you're entitled to a reasonable documentation that request was made and answered. Yeah. I hate that if their agent's really biased against other agents, but that does happen, unfortunately, in the real world. Just talk loud, they'll hear you.
Zoomland can't hear you though. Sorry.
We don't care about those people. I'm just kidding.
No, you're very important. So you travel all around the
Yes.
state, and
Yeah.
there are more affluent and less affluent
Right.
regions. Do you find that buyers are happy to pay for great representation, cash out of their back pocket? Here's 50 grand, agent. Thank you. To be more competitive in areas like the Bay or for certain parts of Southern California, and you
Yeah.
just don't see that, or there's not the financial ability for buyers to do that in other areas?
That's a good question. I haven't heard a lot about that. Even in high-end areas, buyers still don't like the concept of bringing money into escrow. They still want it to be done the traditional way. It's funny. It's because you think about that, right? If you just sold your other house for $10 million and you got all this money, you may not have a problem bringing extra money in for your agent. We haven't seen a lot of that though. It's interesting. It's of course that's possible. Just like in those areas, you're going to see a lot more all cash offers versus financed offers. We may start to see that where their buyers are willing to, since they're willing to pay all cash, they may be willing to bring in the cash for the agent too. Yeah. Right. And the appraisers are supposedly factoring this into their appraisals now. They're not just automatically going by the price. They're looking at the commission part. By the way, here's an issue nobody raised that people hear, but people keep asking is, are you entitled as the buyer's agent to know how much the seller is paying the listing agent? No. Are you entitled as the listing agent to know how much the buyer is paying the buyer's agent? No. Of course, if the buyer is asking the seller to pay the buyer's agent, which I think is the new norm, then of course you do find out exactly how much, because they have to, because since they want you to do it, pay it, they need to know what it is. But it's not a requirement. And your title company may, your escrow company may be doing it differently, but there's no requirement that the listing agent, that on the closing statement, it has to be disclosed how much each agent is getting. We get that question sometimes.
I'll make a comment though. I was in risk management last week and it was interesting that in areas where it was highly populated with doctors and attorneys, they were actually being unrepresented and they thought they could write their own offers. So people with a lot of money. try
That's
to
another
save-
thing too, because you're right. When you buy a really expensive house, they probably have an attorney. And they think their attorney can just do it for them. You're right. Good point. Yeah.
As a listing agent, when you get a call for a showing by another broker, you have the right to demand that they send you the BRBC form stating what the commission is for the buyer as proof that they have a contract before you allow a showing.
Yeah, theoretically, this question is, you're the listing agent and another agent wants to see the property. Said, well, I don't let any agent show the property unless they prove to me that they've actually got a buyer broker contract. In other words, you're saying, I want to police this. I'm going to make sure that people are complying with the law. First of all, you'd have to tell your seller this because that may cause you to miss some offers. But the seller says, yeah, agents shouldn't be out there violating these rules and helping buyers without buyer broker contracts. So yeah, I think that's a good idea. I like the idea of you insisting on seeing that before they can even show the property. If the seller's on board with that, buyers may not want to do it, but you can ask for it.
That concurrently dated BRBC you got with the offer, it's possible it can be different than the first one that they signed with their client,
right?
2 weeks before. And when the offer comes, you may prefer that they use the first BRBC.
But it doesn't matter if you think about it. The point is, why do I even care as the listing agent how much, okay, I was getting at the idea that maybe you care as a buyer, as a listing agent, you just want to make sure that the buyer agent is following the law and not showing properties without a buyer broker contract. But I think you're getting at the amount of the compensation on there. But so what? I don't really care what the compensation is on the buyer's agent's buyer broker contract unless they're going to ask me to pay for it. And if they have a different buyer broker contract 2 weeks ago and they get a new one now with a different number, why do I care what the old one was? I'm going to be willing to pay whatever. And as I keep saying, a rational seller, I don't think is going to care how much the buyer's agent is getting paid. And they're not going to care how much they're asking me to pay of that. I'll pay it if it makes sense with respect to my net, if it makes sense. Now, I know people have already told me there's some sellers say, well, I know that buyer's agent, he's lazy. He definitely doesn't deserve that much money. So on principle, I don't want him to get paid that much. I don't think there are many sellers who are going to think like that. If they're offering you a high enough money that offer is going to be the one that's going to result in the highest net, are they really going to care that they don't like the buyer's agent or something? I think that's too much. I think buyer's agents are getting paid too much in general. Really? Is that going to cause you to not take the best offer you got? Maybe, you tell me, maybe some people are going to think like that, but I don't know. So that's why I don't see why. I don't really care. The only reason I would care as a listing agent to see the buyer broker contract would be just to verify that they're not asking me to pay for more money than they agreed to pay their agent, because that's important. But even then, that could come out at the closing. Let me ask you guys a question. Have any of you guys closed a deal under the new rules? Okay. How did the escrow company decide on how much to pay the agents? Did they demand to see the BRBC? I'm hearing yes and no. What amazes me is some escrows seem to just take the word of the listing agent. How much are the commissions? We'll pay him, and him that, and me that. Okay. I would have thought that escrows are always, would be wanting to see the buyer broker contract. But some people are telling me they're not even asking for that, but some of you said that they are.
I have an anecdote
Yeah,
related to that. So, BRBC was higher than SPBB.
right.
At the end of the counter offer process, right? And first time buyer essentially couldn't afford it. Okay, fine. We'll take a little less. And
Yeah.
then the box was checked, buyer unable to pay.
Yeah,
And then escrow got both the SPBB and the BRBC because that was the whole offer
Right,
package. We
right,
just throw
right,
the
right.
proof right in. And at the closing, they said, oh, on the buyer's sheet, the buyer said, where's this, fee that I'm having to pay you? I thought we talked about that and there was an understanding. I said, yeah, there was. Escrow interpreted it differently.
yeah.
But maybe they should have interpreted the fact that the box was checked, buyer unable to pay, that I have relinquished my claim to the margin.
See, I don't think they should have done that. I think what the escrow company should do is they need to look at everything together. They need to look at the listing contract. That should determine how much the listing agent is getting paid. Then to figure out how much the buyer's agent is getting paid, if I were the escrow company, I'd want to see the SPBB. But I'd also want to check that against the BRBC to make sure that the SPBB isn't higher than the BRBC. So I was just wondering how escrows are
that would be
handling this.
To know how much to charge the buyer for the portion that's not being paid by the seller. But if that box that you guys have put in there
that's an interesting,
is
yeah,
checked,
that's a different question.
do they interpret it?
So in other words, there's a box, which I personally don't like, but it doesn't matter what I care because I'm not the forms committee. There's a
Modification
box
of
on
terms.
the buyer broker contract. What form are you looking at right there?
It's a CAR TBR is the modification
Yeah.
of the terms of the buyer representation.
And that's another form. I mean, that's another form, like the scenario you said is BRBC says 3%, SPBB says 2.5%. The escrow company doesn't know whether to charge the buyer that extra half. If they don't get this modification form, they should. They should say, okay, buyer, that looks like you got to bring in 0.5 point. And the buyer says, I didn't agree to that. So the escrow company would logically want to see the modification of terms where the buyer agreed to take less. I'm just wondering how in the real world, what paperwork escrows are demanding and how they are interpreting it, because escrows are part of this new thing too. Now, he mentioned an interesting thing though. Did you notice there's a box on the BRBC where the buyer can say, I don't have the money to pay you? What is the significance of that? The significance of that is that all that really does is that gives the agent the right to walk away from the deal right up front. But you have the right to give them a 30-day notice anyway. But let's say, related to that, on the first page of the contract, there's a paragraph where the buyer is supposed to, within 5 days, give you their personal and financial information. It's like a proof of funds. So you sign a buyer broker contract with a buyer 3%. Buyer gives you their proof of funds and they actually don't have any money. And then they check that box to verify, I really don't have any money. So now you know you're dealing with a broke buyer. Under no circumstances can they pay you. Now, of course, you're assuming that you're going to ask the seller to pay and they're going to agree. But sellers don't, and based on what I keep saying, sellers should always agree. They don't have no reason not to. But let's say you just don't want to you are so busy as a buyer's agent. You have so many buyers you're working with that this one buyer who is flat out told you they're broke, you don't even want to take the chance that we're going to end up writing an offer. I'm going to go to all the trouble to show them a property, write an offer, seller's going to counter, I'm not going to pay the buyer's agent, buyer's broke, the deal's not going to happen. I want to not even have to waste my time to get to that point. I don't think that's going to happen very often because I think most of you are going to assume, broke as your buyer is, we're going to ask the seller to pay and the seller's going to pay because we're going to still offer enough money. We're going to finance it. So I don't think escrow is going to look at that box. That box means nothing to escrow. What means escrow is they want to know, what does the buyer broker contract said? Was that modified? And what does the SPBB say? They're not going to care that that box is checked on the buyer broker contract where the buyer says, I have no money to pay, which leads to another question. What about the buyer who has plenty of money in the bank? They just don't want to have to bring it into escrow. In other words, can they check that box and say, I have no money to pay the buyer's agent? I don't think they can. I think they can only do that if they actually really have no money. Because a lot of buyers says, yeah, I got 100,000 in the bank, but that's for my houseboat I'm going to buy. And that's for my, vacation I'm taking. There's no way I want to use that money to pay my agent. I want to finance it. But they can't really check that box, I have no money, because they do have money. They just don't have any money they want to bring to escrow for you. But the truly broke buyer, and there are buyers who literally have no money once they put the down payment in, checking that box does give you the option of basically saying, well, I'm so busy, I don't really have time to deal with someone who, if the seller won't do it, the deal's going to fall apart. I don't want to have to waste my time to get to that point.
Now, when you have a buyer like that, who,
Yeah.
and not the guy that's got a lot of money,
Right.
but the buyer that's barely cutting
Right.
it, okay? And you had said earlier, we really shouldn't be calling the listing agent to ask if the seller is willing to, pay a
Yeah.
co-op or some
Yeah.
type of, okay, if you're able to call the listing agent and find out that that seller absolutely will not pay a buyer's
Yeah.
agent, that's what would have saved you the time
Okay.
of writing that
I'm
offer.
not saying you can't do it. I'm not
That's
saying,
that's a situation.
yeah, I
think
understand what
would
you're
be
saying.
helpful.
I was just saying to me, I don't care how broke the buyer is. To me, if I were a listing agent and you called me and said, "What your seller going to pay?" I'll say, "My broker's." Even if you tell me my buyer's broke, will you be able to pay? And I'll say, "Of course I'll pay if it makes sense in the offer." I mean, like I said, I don't see why any listing agent or seller would rationally say, "Under no circumstances will I compensate the buyer's agent." I mean, even if it's a broke buyer's agent, if they make a good enough offer that they're going to get financing for, and it results in me getting a good net, what I'm looking for, the best offer, why would I tell the buyer's agent who asked me this, nope, no matter how good the offer is, I will not pay your agent? I mean, you're right. That's possible, maybe. So it's okay to do it. If you want to, if it makes life better for you to call up the listing agent and get a feel for their willingness, their seller's willingness to compensate the buyer's agent, go ahead and do it. I'm just saying, to me, a rational seller would never say, no way I'm paying the buyer's agent. Why would they say that? If the offer they get is the best offer, are they just going to turn it down because it requires them to pay the buyer's agent? That's what I keep saying. It's okay. If it works, if it makes life easier for you to call them. I just don't see why it would help.
I misspoke, because now I was thinking you were talking about the old days.
Yes, the good old days, yeah.
Now, you have to turn in all paper.
You're talking about escrow now?
But I send also an email, opening letter that also states every timelines and
Yeah.
conditions. And it's all mutually agreed upon.
Yeah.
You usually get a phone call.
I was just curious. I was just simply curious because I still have agents back in the good old days. How did the escrow know how much to pay the agents? And what everyone used to tell me is the listing agent sends them an email. And I would think as the escrow company, they'd want to see the MLS listing to see if the email that the listing agent was sending reflected what was being offered through the MLS. But my impression was the escrow just trusted the listing agent. And I guess the buyer's agent would object if they didn't get what they thought they were getting. Yeah. But so I was just wondering, under the new rules, how escrow, since they're no longer just relying on an email from the listing agent, I was just curious as to what paperwork they were insisting on.
Yeah, the contract says it
Yeah.
relates to.
Right.
To the additional documents that we've added to it.
But the BRBC is not a mandatory attachment to the purchase contract. So that's what I was wondering, are they demanding the BRBC? Are they demanding the modification to the BRBC? Or are they just relying on the SPBB? That's what I was really asking. Good. Yeah. Yeah. Yeah,
Thank you. The one case that I had that was very early into
Yeah.
the process,
right.
the seller wanted to pay a 2%. I had already asked my buyer for 2.5.
Right.
I called her, made sure she understood that she was going to be paying me a 0.5%.
Right.
I emailed the whole thing, lined it
Yeah.
all out for escrow,
Yeah.
included all the
Right.
paperwork. They were still confused because I was one of the first they had dealt
Yeah.
with.
So I think maybe they're all, everyone's adjusting to this. So I was just, that was a pure me being curious question as to how you were running into this.
Just for clarification, the SPB item 3 requires you provide the BRBC.
It says upon request.
Yes, well, that's why we
Upon
always
request.
request it, because it offers that further clarification,
Yeah.
and escrow's required it on all of our files.
Okay, good.
because Of that further
Are
clarification.
you an escrow person? Is that who?
No, TC.
Oh, you're a TC. The TCs who run everything. I understand. Yes. So, by the way, remember the good news, no more SPBB. So, but not soon enough, 2 months from now. Any more questions? Anybody on Zoom?
No, I think that's it. Oh,
We got someone.
Okay, I hope this isn't dumb, but back in the day,
Back in the good old days.
if you would take, let's say you did a tour with a client who wants to see 5 houses.
Right.
That form only has a spot for one address. Do you have to do one for each and every house?
No. The buyer broker contract?
Right.
No, you don't need one for each.
So what do you put in the address?
Well, remember
box?
there's 2 forms, right? I didn't mention this, but we have a short version of the buyer broker contract, which does limit to certain properties, but the BRBC doesn't limit you to certain properties.
mhm.
Um,
I think you're talking about the PSRA.
yeah, maybe that's what you're referring to. We do have another version, maybe I call it the light version. So they're reluctant to sign the full BRBC, committing themselves to you. So how about you just commit to myself for 1 or 2 properties for 30 days or 20 days? So on that form, you limit it to the properties, but on the buyer broker contract itself, it's not limited to particular properties. You do have to put the type of property. Remember, and you always have to always have to fill in the blank about the area. I mean, in other words, maybe someone's hiring you they want you to be their exclusive Kern County agent. But if they want to buy in LA County, they have a different agent. I mean, you can have an exclusive with a geographic area. That's another difference with the listing contract. You have to not only determine how long it is, whether it's exclusive or non-exclusive, you have to determine what area are we talking about. And you even have to put what type of property. If you don't check any boxes, you're saying they're hiring you to buy a single family home only. What if they buy a duplex? You're not covered unless you check the box for, more property. So make sure you check all the boxes. When it says what area, put the entire planet. No, don't do that. Put something reasonable like Kern County or Bakersfield or whatever you want. But you have to think about all these things. Yeah. All right.
Oh, thank you.
My pleasure. See you next time.